Good afternoon. Thank you for joining us today. We have Dr. Gordon, Dr. Rowan, and Dr. McDonald to present Regain Your Freedom legal webinar, which will now begin. Welcome, Dr. Gordon.
Well, I thank you all for joining us today. Today is going to be a very exciting opportunity because I've been sending out emails about a term I call regulatory hell. And we all have problems trying to run our businesses with regulations that are strangling our ingenuity and taking away our freedom. How did it happen? Well, today you're going to meet somebody who's really researched this in great detail, Ronald McDonald, who's worked very closely with a real freedom doctor, Dr. Robert Rowan. And I'm involved only because, having been the co-founder of ACAM, I have wound up defending doctors in front of at least 30 different medical boards. And I've had to sue the AMA and the Medical Society, and I've had to sue the Medical Licensing Board of California, and I've had to take things up on appeal. So because I've spent a lot of money, I'm hoping to save a lot of you from what I've gone through. And so what I'm hoping to do is today move into a brief introduction. The currency is where problems really start. And if I have to switch the topic to that, because if we don't understand that with the money going through this nonsense that they've done when they took away gold and silver and they can print them as much as they can, that's when a lot of things occurred, which we will explain to you today. But I want you to understand that Ron McDonald is a Vietnam veteran who spent 25 years studying the law. That's all he does. It is his passion, and his key interest is the inherent rights from which all other law arises. And I believe that he has been gifted to find some answers, which if he can download some of these answers into our minds and we can share them with our colleagues, sanity can be restored. Dr. Robert Rowan, I've had the privilege of working with for many, many years, and I really want you to know that he is really a walking encyclopedia on medicine. And I argued with him. I said, how can you take all this time to study law? Because you really are great in alternative medicine. He said he is driven to it. He says he has no choice. So with that said to you, I need to know that we're starting now with the topic, Reclaim Your Freedom, and I wish to turn it back now to Dr. Rowan.
Well, thank you, Gary. My screen will be seen in just a moment as soon as you click it.
Something has happened to my screen and I can't push it back right now.
Got it.
Okay. Good.
I got it.
Okay, very good.
I believe that you should see money in gold. Is that correct?
Yes, we do.
All right. The topic of today is the money system. That's the most important thing. And for those who have joined us, please know that we're going towards the end of this. We're going to be discussing licensure in depth. Those are the two key issues for us: money and licensure. Now, here's the definition of insanity, and that's what's going on in the government today. Fathom the hypocrisy of a government that requires every citizen to prove they are insured, but not everyone must prove they're a citizen. And now, any of those who refuse or are unable to prove they are citizens will get free insurance paid for those of us who are forced to buy insurance because we are citizens. That's the insanity of what's happening in government today, and we're going to show you the cause. This is the book that Ron and I co-authored. They own it all, including you. I strongly encourage you to get this book and read it. It's the basic foundation of what's going on in the currency. You can get it at Amazon. This is what's on the cover of the book. I care not what puppet is placed on the throne of England to rule the empire. The man who controls the British money supply controls the empire, and I control the British money supply. Now, put that in the context of the currency that we're dealing with. I know there's a lot of people out there listening to this. I'm going to ask you a question. How many of you have constitutional rights or want constitutional rights? Ron, why don't you answer that question?
Well, if you want constitutional rights, you fall under the 14th Amendment, and your rights are passed through that amendment to the First State Bill of Rights. Those rights are statutory in nature. They can be repealed, they can be revoked, they can be amended. However, these are your privileges and immunities. If you prefer to have unalienable rights, you get that from nature, and those are immutable rights that are within the man or the woman. They come just by your very nature of being human. And these rights cannot be tampered with. They cannot be taken away. They cannot be reserved or licensed or all the myriad of things that the state wants you to think can happen to these rights. So those of you who want your statutory rights, you fall under the Constitution. Those who want their immutable rights, you fall under the law of nature, or God's law, basically. And this isn't a spiritual statement. God's law is an infinite law, the qualities of which come right back down to you with all the infinite rights that a man can have. And this is the only issue why government is created, to protect and keep standard those rights among us.
I want to point out that even this, look at the bottom paragraph here. Even the Second Amendment recognizes the people's existing right to arms. It doesn't grant a right. It simply says the people's right to keep and bear arms shall not be infringed. That's a pre-existing right. Ron and I want to exhibit our unalienable rights or unalienable rights. These rights arise out of the common law of the land, called the common law. And it was enshrined in the Magna Carta, which comes to us this day even through the Constitution's Due Process Clause. It says, "No free man shall be dispossessed of his liberty or property, absent by trial of jury, according to the law of the land." Now I want you to think, please think for a moment, how many of you, physicians or non-physicians, are getting your, whatever you think is your property, taken from you, absent a trial by jury, and certainly not according to the law of the land, the common law. When you walk into a court, believe it or not, you're in an admiralty court. You'll see that.
I would just like to interject, anyone who's been hit by your medical board or any type of administrative agency, you'll see the caption, and the caption is that part of the upper left-hand corner of the complaint. And in your state, it'll say the people of the state versus you. But in an administrative court, such as your medical boards and stuff like that, it'll say in re, in the matter of you. There are no people included. You're not judged by people. You're judged by a fiction of law.
You're judged by, yes. In the common law, we have absolute freedom to do anything you want to do, just as long as you don't tread on the rights and liberties or damage another. The Declaration of Independence is the foundation. It says all men are created equal, and they are endowed by their Creator with certain unalienable or unalienable rights. What does that word unalienable mean? That means that when you came into this world, you have rights that cannot be severed from you under any circumstances. You can't even voluntarily give them up. You can look that up in an old law dictionary. Ron, you want to go through the fundamental principles of unalienable rights on this slide?
Okay. Yeah, well, the fundamental principles of unalienable rights are all the rights that pre-exist before the enactment of your federal Constitution or even the Articles of Confederation which preceded the Constitution. That means the right to own property, the right to do with your property as you wish, the right to marry, the right to build a fortune, to have wealth, the right to have children, the right to travel freely, the right, I mean, there are infinite numbers of rights, including the right to breathe, to have a perimeter around you when you stand that no one can come into that perimeter. These are your immutable rights. And
perhaps the right to health care of your choice.
Oh, absolutely. And in fact, you cannot, under restraints or by compulsion, be compelled into contract. That is one of your rights. And we all know about the Obamacare. It's kind of compelling everyone to do something eventually. But this is what the right actually pertains to. And no police power by either the state or the federal government can penetrate those rights. But what has happened is the state and the federal have encroached upon our rights because of our ignorance. But we do have a remedy to push them back on that.
Now, how can we prove that the people came first? Because everybody thinks of constitutional rights. Well, in this slide at the bottom, this is Marbury versus Madison, one of the most famous Supreme Court cases ever. And here it says, the Constitution is certain and fixed. It contains the permanent will of the people. It says the permanent will of the people, and it's certain and it's fixed. And then it says the Constitution is the work or will of the people themselves in their original, sovereign, and unlimited capacity. Please pay attention to those words. The cases that came forth after the nation was founded are at the source. Ron calls it, the water is purest at the source. The Constitution,
Then at the mouth, Robert, because at the mouth of the river it flows through farmlands, and God only knows what goes into that water. Which area do you want to take a sip from? At the source or at the mouth of the river?
I'd rather be right at the spring where the source is. Now, you know, even our modern progressive rulers and even current justices think the Constitution is a living document. But you just saw the Marbury versus Madison case. It is certain and fixed. And you can't change the meaning of words. Ron, you brought this one to me. Comment.
Yeah, the United States Constitution was enacted under a war. So it was under a state of emergency. So all the powers ever necessary to perform this government into a nation was right there, right within that instrument. It did not need a living document to progress on powers of war or emergencies. Those are actually contained there. And as it says right here, a law and its application can only be changed by Congress either by the abolition of the old law and the passage of a new law, or by an amendment or of the old law, clearly showing that Congress intended for the law to have a new meaning. We cannot wish a new interpretation into a law or give it a new application merely because the situation which caused its passage had ceased to exist. Does that mean that we can change the nature by implication? Can the government change the nature of a law by implication, such as the Coinage Act or the Article 1, Section 8, Clause 5, the right to coin money? Can they interpret that and make a new interpretation of it and make legal tender out of that act? No, they cannot. And this is the law that proves it.
In other words, they can't change the meaning of money. Money at the time of the Constitution was coin. We're going to get to that. At that time, the right to contract was absolute, and under common law, payment had to be in specie. Specie means gold or silver coin. When you tendered the coin, you took absolute title instantly of what you purchased. You didn't have any recourse to go to the state to complain, but you could sue the perpetrator of a fraud if a fraud was brought upon you. All rights must arise from your ownership of property. The founders knew this, and Gary could chime in on that in a moment, but why? Because the ability to contract with another, you have to have the absolute title rights and interest into whatever you are offering the other as part of the contract. Gary mentioned what you just read in the Wall Street Journal.
I want everybody to know that this is last Saturday's book section on Revolutionary Summer, the Season of Liberty, and what they're telling you is that what we have is the concern of John Adams is that if we allowed the electorate to include propertyless men, no way, John Adams said, there will be no end to it. Every man who has not a farthing will demand an equal voice with any other in all acts of state. So in other words, what he's saying is that when our founding fathers built the United States, they did make a distinction between people who had property and people who did not have property, and that is a key part as to where you're going to have to understand today's presentation so that you can regain standing to get into a proper venue, a proper court, where you will have the ability to be defended by the Constitution, because if you walk in and you are propertyless, you are in a court in which you will not be able to argue anything from the Constitution to any effect. So I'll turn it back over to you, Robert.
Yeah, I have a comment too. In that circumstance, those without will prejudice those with property for their own benefit, and that's the real underlining concept in that.
Now, let's talk about the common law one more time. The common law really rose out of the Ten Commandments. Thou shalt not steal, thou shalt not murder, thou shalt not do all kinds of bad things. And we know that. That's common law. You don't need to be taught that. You know that. That's where the term ignorance of the law is no excuse. That meant common law. But today, you could be ignorant of a Medicare regulation. They'll say ignorance of the law is no excuse. You're going to jail. And you didn't hurt anybody. Now, in the common law, property could be gold or silver. Why? Because gold and silver is considered portable land, and you owned it outright. It's been used since biblical times. In biblical times, we have the scales of Solomon, where on the right you see the law represented by the Ten Commandments, and you have gold coin, gold, on the opposite side. Ron, comment on that.
Yeah, that they're in perfect balance says a lot. But what happens if you change the gold or the actual money, the gold and silver coin, and replace it with paper that has absolutely no value but confidence? What happens to the scale at that point? Does law become heavier?
Yeah, we'll see that in a moment.
Okay. Well, that's basically, this is the scale of Solomon, as you can see. But it had to be a perfect balance in order for rights to be protected.
If you were a debtor in the common law, you didn't have any rights. You only had the privileges your creditor gave you. Privileges? Why? Insolvency was a crime. It was subject to imprisonment. Why was it considered a crime? Because if you couldn't pay your debt, it was considered theft. You were owned by your creditor until you repaid. Well, think about that in terms of what's going on in society today. Also in the common law, the jury could judge the law as well as the facts. In common law, to be punished, there had to be an injury in addition to an action. And for a crime in the common law, your action had to be intended. An intended action plus an injury, that's a crime. In commercial law, which we physicians are subject to today, and perhaps non-physicians listening, non-licensees, an action only is a crime. For example, improper Medicare filing. Or in the case of a doctor I just spoke with a half an hour ago, he was doing chelation therapy and no one was injured. And they stripped him of his license and destroyed his life. Common law versus admiralty. Common law is the law of the land. Admiralty, maritime, is law of the sea, contract law of the sea. It starts in ports, crosses boundaries, and ends in ports, except for the thing we're going to be discussing today. Ron says that maritime is this law in a time of peace, admiralty is this law in a time of war or emergency. There's only two jurisdictions in the United States in the federal system providing for criminal penalties, admiralty, and common law. Is that accurate, Ron?
That's accurate.
In admiralty, we see bills of exchange. Unlike what you were paying in common law, which was specie, gold or silver, you could give a promissory note, which is called a bill of exchange. What about hypothecation? That's important because think, if your ship came into a port and you were loaded with furniture and there was no one there to pay you, you didn't want to take your furniture back overseas, you'd leave your furniture there and there was a maritime hypothecation attached to your goods, meaning you own them. You could come and get them anytime and seize them in maritime law if payment wasn't made. Bills of exchange were used for conveniences for merchants who would prefer not to carry gold coin, vulnerable to pirates and thieves. Now in the common law we didn't have that. In the common law you actually had to make payment. Here's a sad commentary on the war. Gary brought it up. Those revolting were aristocrats. They were landed. They were heavily into commerce. The king wanted to tax them on their activities. The aristocrats didn't want to have anything to do with it. So to raise armies, they promised the common man land, which is the source of rights. Sadly, in the end, many who fought for the aristocrats were screwed. They didn't receive the land outright, but they became tenants on the aristocrats' land. Now, if you don't think that you have sovereignty in yourself, here's a Supreme Court case, Chisholm versus Georgia. The Supreme Court said, and this is a quote, at the time of the end of the war, the sovereignty of the king descended upon the people of the land except for the African slaves. The people themselves instantly became kings without subjects. The colonies, which had been corporate charters of the king, became sovereign states. The people were citizens of their states. Ron, you wanted to mention allegiance and citizenship.
Oh yeah, there's case law that allegiance is basically that of a feudal man on the land that is a subject of a higher power. However, citizenship is that of mutual loyalty. And in this country, citizenship should be one sovereign to another, and that's where it should rest. So allegiance is vulgar in accordance with the law. It's for those who want to be, or those in servitude, and must be subjected to a higher ruler. But
now,
again,
I was going to say, what they're reading in front of them, Ron, is directly out of a Supreme Court case, correct?
Yes, it is. And that case is, and I'll give it to you in a second, Tabbitt versus Jansen. It's 3 U.S. 133. The 3 stands for the volume. The U.S. stands for the book itself, and 133, it starts at page 133.
Allegiance is repulsive. So when you pledge allegiance, think about that. It's repulsive. Citizenship can be relinquished. Allegiance is perpetual. Now, the states antedated the United States. The states came first. They were the creators of the United States. In fact, Ron and I live in California. The Article 2, Section 1 of our Constitution says all political power resides in the people. This power comes from the common law, nowhere else. We were able to delegate certain of our common law powers to the state, such as the power of protection and defense, and the state in turn could delegate certain powers to the central government for good cooperation among all the states so that they wouldn't be at war with each other. However, all powers not so enumerated and delegated remain with the states and with the people. So think about this. How does the state get to do what you yourself cannot do to another, such as sticking a gun at you and commanding you to empty your wallet and turn it over to someone else, like pay for their insurance or their booze or their junk food or anything else? Or coming in between a contract for employment with a private party. How do they get to do that? Because I can't do that. I can't go to your business and tell you how you have to enter into a contract and limit it. The answer to this question provides the means to its remedy. In fact, here's another Supreme Court case. We're not going to give you the cite for this one, but I want you to read the red in the middle of this. A law that takes property from person A and gives it to person D is contrary to the first great principles of the social compact and cannot be considered as a rightful exercise of legislative authority.
You need to turn the slide, Robert.
I need to turn the slide?
Yeah, you're on question. So how does the state get to do? There you go. Yep, you passed it. There
Okay.
it is.
It must have taken some time to come through. Or a law that takes property from person A and gives it to D is contrary to the first great principles of the social compact and cannot be considered as a rightful exercise of legislative authority. Hello. Please think about everything that's been done since Roosevelt and the New Deal and the Great Society and Obamacare. Go ahead, Ron.
This goes right back to the very law we stated earlier about what is the purpose of government but to protect the rights, immutable rights of the people. And the immutable rights of the people does not allow one citizen to take property from another without payment. So it doesn't lend itself to the government to take that quality in itself or power within itself.
At the founding, God was at the top, then man, then states, then United States. You need to know that a Supreme Court case said that the United States are a corporation. Hello, your federal government is a corporation endowed with the capacity to sue and be sued, to convey and receive property. The central government is a corporation. It was created in international law among sovereign states. 13 sovereign countries created a compact and an entity, a corporation called the United States. Is that accurate, Ron?
That's accurate.
Key powers delegated: defense, post office, roads, regulating commerce amongst the states, not trade amongst the people. And here it is, to coin money. What's money? The Constitution says Congress shall have the power to coin. The verb is coin, and the noun or the object is money. So what was money? Money was gold and silver. You can look at any dictionary back then. Money was gold and silver. Congress was granted the power to shape money, metal, into coin. It wasn't empowered to create money. You don't see that in the Constitution. And that was memorialized in the Coinage Act of 1792, where the only definition of a dollar still exists to this day, which is a fixed weight of gold or silver. Now, what does the term regulate mean? There's only 3 clauses in the Constitution that use the word regulate or regulation. Only 3. Coinage. Congress shall have the power to coin money and regulate the value thereof, which you'll see here means keep regular. The Commerce Clause. Congress shall have the power to regulate commerce among the states. It doesn't say it has the power to destroy it. Now the next one is very important. Congress has the power to make all needful rules and regulations respecting the territory or other property of the United States. I want you to please remember that one when we get to the Federal Reserve note. The people of the states were not property, hence they were not subject to central government powers. Here are the sources of the definitions that we're going to give you. Remember, Ron, explain to them that laws and the Constitution have to be interpreted in the words and the definitions used at the time?
Well, you just did hit, but that's the true statement. True statement.
So we're going now to a universal etymological English dictionary in 1792, which you can find online. Google Books has done us a great service. And Bouvier's Law Dictionary, which is abbreviated BLD, which is 1853. And we also have the Lex Mercatoria, which comes out, which is not in here, which comes out of the 1780s. The English dictionary said that money was a piece of metal stamped with the effigy of the Prince of Arms of a state, which makes it current, which means makes it legal, Ron, correct?
Yes.
And authentic to pass at a common rate. The word current means the state recognizes it as legitimate.
Or currency.
Or current.
Yeah, establishes a currency in society.
So it's a piece of metal. In Bouvier's Law Dictionary, what is money? Money is gold, silver, and some other less precious metals in the progress of civilization. It's dealing with weights and quality. Whenever passed, they've caused them to be manufactured in certain portions. That's to regulate the value, and marked with a stamp which attests their value. This is called money.
I think it's important to say that
also,
there is...
Bouvier says, go ahead.
Yeah, it's important to say there is a purpose for guiding you through the money system, because the end result is what we're after. What we're going to do at the end result.
Now, for the many purposes, banknotes. Okay. Banknotes, the definition of banknotes at the time, issued by a private bank that was redeemable. By the way, Ron, you have some mouse control here.
Oh, okay. Oh, sorry about that, Robert.
That's okay. Now, here's banknotes from Bouvier's Law Dictionary. Payment of them. A banknote requires payment. A banknote's not money by itself. A banknote has to be paid on. They're treated as money because there is payment on them. Money was precious metal, but money was considered also to be redeemable banknotes. Constitution, Article 1, Section 8, Clause 5. Congress shall have the power to coin money, regulate the value thereof and of foreign coin, and fix the standards of weights and measures. This is all one paragraph. The weights and measures are tied to the coinage of money. And here it says regulate the value thereof. Regulate the value thereof doesn't mean that you change a dollar from, let's say, 1 ounce of silver, I'm just throwing this out, to 1/10 of an ounce of silver. Regulate the value thereof means that you keep regular those coins. Is that right, Ron?
Yeah, well, you know it because apply the second part of that sentence. Congress shall have the power to coin money and regulate the value thereof of foreign coins. I doubt that very much that the foreign country would allow that to happen. So that term regulate has to mean something specific. It must mean keep standard, keep uniform in correlation to the currency of the United States.
Well, at that time they didn't have currency.
Currency is anything that flows through society as a money system. Species is currency.
Okay. No, here they were not given the power to create or fabricate money. They were only given the power to coin money. We're going to see how that changed. This constitutional power was exercised in the Coinage Act of 1792, which is in full in our book, an act establishing the mint and regulating the coins of the United States. It defined a dollar as gold or silver, and the ratio of silver to gold for dollars was about 15 parts of silver would be worth 1 part of gold in terms of weight, in terms of dollars. The coins were to have an impression of liberty, with the word liberty inscribed, and an eagle. There is the effigy of the king. Remember, we mentioned that a few minutes ago about money of states. Gold and silver coins were to be the standard of alloy. In the Coinage Act, the money of accounts of the United States shall be expressed in these dollars. Hello. The money of accounts of the United States shall be expressed in these dollars. The dollars were silver and gold or parts thereof, tenths, hundredths, and thousandths. That was the money of the United States. Go to the next paragraph. This comes right out of the Coinage Act. All proceedings in courts of the United States will be kept in conformity to this regulation. The courts of the United States were to be held in specie dollars. The seriousness of honest money. The Coinage Act imposed a penalty if any coin that came out of the mint was deliberately less than what it should be. The penalty was death. That's right in the Coinage Act. That tells you how the founders knew the importance of an honest money supply was. The people brought in their own bullion for coining. It says that it shall be lawful for any person to bring to the said mint gold and silver bullion in order to their being coined. In other words, the ownership of that came from the people themselves, and the mint coined it as a service to the people. The mint made its money when you brought back your coins to melt it down to bullion, because in some cases, bullion was actually more valuable than the coins. We're not going to get into that. Now, this is crucial. This is out of the Coinage Act. All the gold and silver coins which shall have been struck and issued from the mint shall be a lawful tender in all payments whatsoever. Those of full weight, meaning they haven't been worn, according to their respective values before declared, and those of less weight, meaning if they're worn down by half, at values proportional to their respective weights. So they're telling you here that the coins that came out of the mint had value based on their face if they were full, and on their weight if they were worn. Ron, comment on what the word lawful tender means compared to legal tender.
Yeah. Lawful has the elements of both form and substance. Like the coin itself, it has a form. It's cylindrical. It has the shape, and then its substance is the gold itself. So that's lawful tender. But when you have legal tender, such as a note, if it's redeemable, it appears to be money, but in fact it is only the representation of money. Anything legal is the representation of that commodity that's written on that document. For example, you go into court and you have an attorney who represents you. So he's actually a legal representative. You would be the lawful representative representing yourself in that sense. So that's basically the difference there. And it's the same thing as that you could have a legal fraud, but you can never have a lawful fraud.
And Ron just described that important term. It connotes common law payment, which requires specie. The debt is paid and immediately extinguished. No vestige of the debt remains. And here's the term regulate, to make regular. Be it further enacted that it shall be the duty of the respective officers to use their best endeavors that all the gold and silver coins which shall be struck at the said mint shall be, as possibly can be, conformable to the several standards and weights aforesaid. That's what the term regulate means, to make them uniform. Nothing else. The coins of the United States remained regular until 1853, when there were great fluctuations in gold and silver due to the great gold discovery out here. Congress then went and debased. It did something it shouldn't have done. The silver coins of denominations of less than $1 by 3%. That was the first act of Congress in attacking the money system. And they called those silver coins legal tender, in contrast to the lawful tender of the full weight coins. One silver dollar at the time, 1853, contained 0.76 ounces of silver, but 4 quarters were reduced to 0.73. What about paper? Until the outbreak of the war between the states, the only paper that came out were private banknotes, all of which were redeemable. They were the bills of exchange. There were attempts at a national bank, but it was destroyed by Andrew Jackson, whose image is now posted on the fraudulent reserve notes, the $20 piece. A bill of exchange is a note ordering a sum of money to be paid. It's not money itself. Money was specie. What happened in the war between the states? Lincoln didn't have the money to prosecute the war. And by the way, it wasn't called a war at the time. It was called an insurrection. So when they tried to use war powers, that should be brought into question because they didn't call it a war. Lincoln fabricated legal tender paper currency and forced it upon the people. This was engineered by Treasury Secretary Samuel Chase, who later became Chief Justice of the Supreme Court. And you will see that as Chief Justice, he actually ruled against his dastardly acts in creating paper currency. He said it was unconstitutional. I want you to note now, I'm going to take you through this because this took some time to grab these images. The first greenbacks were not legal tender. This was the first greenback. You can see here, 1861, United States of America. Now note, this is really important. Promise to pay to the bearer here on demand $5. So this isn't $5. It's a promise to pay to the bearer on demand $5. This is the first legal tender note issued by the United States and compelled upon the people. Actually, this is not legal tender yet. This is the first currency issued by the United States. Because you'll notice here there's nothing that says it's a legal tender. Congress then foisted legal tender status on this piece of paper. Right here. This note is a legal tender. Ron, is my cursor coming through okay?
Yeah, it is. Yes, it is.
Okay, thank you. This is $1, and it says, "Will pay the bearer $1," and it's legal tender. Ron, explain what that word means.
Legal tender?
Yep.
Is that what you want me to explain, Robert?
Yes.
Legal tender?
Mm-hmm.
Yeah, legal tender is a compelled restraint on the people as far as how these instruments are to be used. Legal tender makes it payable for all debts and all private or public. I don't know if they had that public and private on this, Robert. I can't see it on here.
It says
Yeah,
for
okay,
all
so
debts, public and private. See my cursor?
okay. So with the legal tender clause on that, it now is a enforceable certificate to pay debts and public and private. That's basically what it is.
In other words, I want you to see what this did. And this is why it went to court. Suddenly, during the war, someone who loaned gold, specie, could be repaid in paper. Hello, that created chaos. Now, the paper did say redeemable, but it wasn't redeemable during the war. That's why it wasn't wanted. And it traded for about 40 cents on the dollar. The central government was broke, and it financed the war with these promises to pay. What you need to know is the power to emit these bills of credit was deliberately stripped from the Constitution. Ron, tell them that.
Yes. In the Articles of Confederation, they had the clause, the states can emit bills of credit. But because of the depreciation of the bills and things of that nature, it set man against man and man against government. It caused havoc in the entire continental union of states at that point. So they took a vote at the convention. On Madison's notes, it says 11 states to 2 decided and determined that emitting bills of credit will never be a power of the states because of what it has caused. And even during the time that they were using these legal tender bills, states were compelled to double the security of the face value of that note to prevent the depreciation of the bill when one wanted to get their gold commodity in exchange for it.
There were a slew of cases that arose about this, people screaming that Congress impaired the obligation of contracts. The notes were circulating for about half their face value because they weren't redeemable. There were contracts that were entered into before these legal tender acts were passed. Those contracts were debased because they could be discharged with paper. Several state courts found that the notes were unconstitutional. They said Congress was not empowered to emit bills of credit. Well, we know from Madison's notes that's absolutely true. It was deliberately stricken. The states found that only gold and silver coin could be money, and contracts were being violated, meaning theft. The first case to arrive at the U.S. Supreme Court held that the legal tender acts were unconstitutional in a 5-4 decision. However, cases repeatedly came back to the Supreme Court, and it reversed itself 5-4, and that was determined by which corrupt president was appointing people to the Supreme Court. In this case, it was Grant who filled 2 seats in the Supreme Court with people who were pro-paper. The Supreme Court fabricated a power, look at the last paragraph, that was not specifically enumerated, emitting bills of credit. So how did the Supreme Court fabricate that power when they actually admitted in their rulings they acknowledged Madison's notes? So how did they find that it was constitutional? Here's how they did it. The court held that the Congress had the power to declare war. Remember, the Civil War was never declared as a war. It was an insurrection. But they said there was a war power. So Congress had an implied power to do everything possible to prosecute the war. Well, Congress did have an express power to coin money, and they had an express power to regulate the value of money. So they combined these powers. The court held that Congress could emit bills of credit under the combination of war powers and the power to coin money. What I want you to remember is what Ron told you at the start of this about emergency. Ron?
Yeah, the emergency clause is that the Constitution was created under war powers. We were in a Revolutionary War at that time, so all the powers were pre-thought to be intended within the instrument as it stood, expressed in the instrument itself. So there would be no grant of further powers in a state of emergency. So they understood that money was money. It was gold and silver at that time. No one would ever consider that producing paper or legal tender money, which is not redeemable, would ever be a war's power. It's just not there. It can never be there, because once it is there, it goes back to those immutable rights of the people to own their property, to have wealth in that. Well, that's the only purpose of government, is to institute the protection of that property. And if they remove the money, as they did today, they've removed the rights for which they were created. And those rights to be protected was the property of the people.
Now, the final legal tender case was Juilliard in 1884, and this is the standard by which all further cases are held to. They all fall back to Juilliard. Juilliard just pooled all of the legal tender cases that the Supreme Court sustained. And even though they were only sustained by 5-4, the Juilliard case was 8-1 because the Supreme Court doesn't like to overrule itself. So here's what the Supreme Court decided in the Juilliard case. Now, you're going to find this most interesting. By the time the Juilliard case came around in 1884, Congress had already begun to redeem those greenbacks. However, Congress decided to keep some of those greenbacks in circulation and reissued them, even though the war, and remember, they based the ability to emit these bills of credit on the war power. So this case was heard regarding the ability of Congress to keep reissuing paper and mandating it as legal tender in a time of peace. Here is a quote out of that case, and it deals with implied powers. Everything here except the brackets, and I put the brackets in to enumerate the qualifications of those notes. So there's 4 qualifications. I want to read this to you. The court said, quote, "The single question therefore to be considered, and upon the answer to which judgment to be rendered between these parties depends, is whether, 1, notes of the United States," I repeat, notes of the United States, 2, issued in a time of war under acts of Congress declaring them to be legal tender in the payment of private debts, so they had to be issued in the time of war and issued by the United States, and 3, afterwards in the time of peace, redeemed and paid in gold at the Treasury. And then 4, reissued under the Act of 1878. Can these, under the Constitution, be a legal tender in the payment of such debts? Look at those 4 qualifications that this court judged legal tender on. Read it again. Notes of the United States, issued in a time of war, and redeemable, and then reissued. Keep them in mind. So the court made its decision politically on this one. This case actually was decided 7-1 or 8-1 because of the previous 5-4 cases. They didn't want to overrule themselves. However, Chief Justice Chase, and I think it's on the next slide, let me see. It's not, but we might get to it. The Congress, here's implied powers. The court said that the Congress was granted power to carry out its enumerated powers with the necessary and proper clause. That dealt with war. So it was necessary and proper to do this to prosecute the war, which was not a war. They never declared it a war. It was a rebellion. Now, what is an implied power? In the Coinage Act, even though the Congress didn't say it's punishable by death, the Constitution didn't say that debasing the coin is punishable by death, Congress could. This is an implied power out of its express power to coin money and to sustain emissions of bills of credit when such power was stripped at the Constitutional Convention. That could not be an implied power. It was actually stripped. As I said, the war was never declared. So the Supreme Court created a new power for Congress. The Congress went much further by continuing to issue and reissue these bills of credit after the war. So the court continued to unconstitutionally expand the power of Congress. If it really was a war power, how the heck could they get away with expanding it and saying you can reissue it in a time of peace? Political. And here is former Secretary Treasury Salmon Chase. He repeatedly held as Chief Justice, he screamed in his dissents that his acts as Treasury Secretary were unconstitutional and the Legal Tender Act should be held as void. But he lost by a slim 5-4 majorities due to the politics of his day. It's interesting that the architect of the acts was to come 180 degrees and hold that what he did was unlawful. Ron already told you emergency doesn't create power. In a period of grave emergency, we went through this slide, so I'm going to go to the next one. Emergency doesn't create power. But Ron, this is a recent case, isn't it?
Yeah, it is.
This is a 1950 case.
Yeah, 1950 case is correct.
Look at this. Emergency does not create power. So here we have a 1950 case telling us that what Juilliard did, all those legal tender cases in a time of war, they couldn't have done because the emergency couldn't create the power. Am I right?
You're right on point, Robert. For the Congress to create a new power, when it has enumerated powers, to create that new power actually voids out that power itself. It cannot be done without the consent of 3/4 of the states.
So an emergency doesn't create power. The court back in a 1950 case could be used to overturn that crazy, the crazy legal tender cases that said that you could combine 3 powers to fabricate a power that wasn't there before. So we're revisiting the Juilliard case. It set the future of paper currency. Notice the conditions. Notes of the United States, issued in a time of war, and afterwards, in a time of peace, redeemed, and then reissued. Please burn those 4 requirements in your mind. And the court decided that the notes meeting those 4 conditions were indeed constitutional under implied powers. Now let's look at one of those notes. A United States.
I think it's, Robert, I think it's important to say the Secretary of the Treasury at the time was Dallas. And this was about
No. This was 1820.
No. I'm going back in time. With Dallas. He was the first one to say or state that it was an express power within the government to create legal tenders. And he well knew that the states had already voted on that act to limit emitting bills of credit. So we can see the encroachment starting very early in this country.
It was deliberate.
Yes.
Let's look at a United States note. Here's one. This is a 1928 United States note. It says up at the top, United States note. The United States of America will pay to the bearer on demand $5. So this is not $5. It's a promise to pay $5. And it says over here on the red seal, which you can't see very well and I can't see, that it's redeemable at the Treasury. Clearly it was not money. It was not dollars. It was, look at this, will pay $5. It was legal tender. What about a gold certificate? Here's a gold certificate. Now suppose you had one of these today. This certifies, first of all, I'm going to say, whose property is the gold? Look at this certificate. This certifies that there has been deposited in the Treasury of the United States of America $20 in gold coin payable to the bearer on demand. Now I'm going to ask you again whose property that gold is. If you have a baggage claim check at the hotel, does your luggage become the property of the hotel or is it yours and they're holding it in custody for you until you present your claim check? This is my gold, or your gold if you have that certificate. And if they don't give it back to you, then what just happened? We'll get to that. We're going to fast forward to 1913, the Federal Reserve Act. The Federal Reserve Act at Title 12, Section 411 defined a Federal Reserve note as obligations of the United States denominated in dollars. Obligations? That's another term for debt or duty. Denominated in dollars, it doesn't say they are dollars. They're denominated in dollars. The appearance of dollars. We will show you a picture at the time. They were redeemable in dollars. Generally, when you have a note, the maker or the creditor is at the top of the note. The debtor is underneath. When the acts were passed, the notes were redeemable. You can see it in law still today. They shall be redeemable in lawful money on demand at the Treasury Department or at any Federal Reserve Bank. Here's the note. Series 1928. Redeemable in gold on demand or in gold or lawful money lawful money could be silver. That was lawful money at any Federal Reserve Bank or at the U.S. Treasury. And it says here, will pay to the bearer on demand $5. So this is not $5. It will pay to the bearer on demand $5. And note, it does not say legal tender on it.
You know, I think it's also important to bring a point across, and that is that represented what you owned in the mint or the treasury. You owned that gold. This only was a representation of it.
It was your claim check.
Yeah.
It was your claim check to your property. So let's go forward a little bit. Note qualities. Not legal tender, and it was redeemable to the bearer on demand. So the coin that was held at the Federal Reserve Bank or the Treasury was your coin. And because it was not legal tender, you are not compelled to accept those notes. Please note, who is issuing said notes? Let's fall back to Juilliard. The first condition was notes issued by the United States. Well, in Title 12, Section 411, it says, Federal Reserve notes, I clipped and pasted this, to be issued at the discretion of the Board of Governors of the Federal Reserve System for the purposes of making advances to the Federal Reserve banks. These notes are issued by the Board of Governors of the system. These notes are issued by the Federal Reserve System. It says it right in the law. Now, we're going to come back to the currency in a moment, and I want Ron to talk about the catastrophe that happened in 1933.
Yeah. Well, what led up to that, shortly before 1933, the United States did something that was not an express enumerated power under the Congress. And what it did, it loaned money to foreign debtor nations, such as England and France and Germany and so forth. And it loaned the American people's money. Now, there is no express power for them to ever loan. They can borrow, but they can never loan. And what happened, they put a moratorium of 1 year. That meant that the debtor nations didn't have to pay back for 1 year. So they had millions and millions of these notes out there, and immediately these foreign debtor nations came back to the United States with these notes and started clearing out every ounce of gold they could get. They had tankers coming back and forth into the repositories of the United States to pull that gold away in order to collapse the gold standard here in the United States. The problem with this is, first of all, the United States committed a fraud against the American people because it showed loyalty to foreign nations and not to the nation, not to the American nation itself. The next thing that happened is, because this had occurred, President Roosevelt turned around and said, the American people are hoarders, and it's a crime to be hoarders, so all Americans are hoarders and they're criminals. They must turn in every gold certificate, every gold coin, and etc. And if they do not, and they did this at gunpoint in several areas, if they do not, they will suffer the penalty of 10 years in prison and $10,000 penalty.
In other words, they became an instant felon, a high felon, for not turning over their property.
Absolutely. How does the servant claim that the master with his wealth must turn his wealth over because he's a hoarder? And that's the simplicity of it.
I want the listener to know that Ron and I have been on the phone for hours, almost in stitches, about making holding your own property a crime.
Now to go back to that, the case that was presented earlier, the people had immutable rights. Among those rights were the right of ownership of all property, including their money, their wealth. And governments are instituted only for the protection of those immutable rights, nothing more, just the protection. And they're not given the power to restrain them, license them, or anything else. And here we have, in 1933, all Americans being accused of being criminals.
Oh, no, they weren't accused. They became criminals.
They became, you're right, Robert.
They became criminals for holding gold, and the only way they could not stay a criminal is to turn over their gold.
Yes.
And the point Ron was making is so important. We loaned paper to France and Britain, but they were redeemable paper, and it didn't have to be paid back for a year. So during that year, they pulled a fast one. And don't think this wasn't orchestrated. Yeah. They redeemed those notes for the gold. And they ran away with our gold, and then the government was goldless, and then they came and stole the people's gold.
Yeah. What does it imply, though, Robert? It implies that the United States government and Congress printed up more gold certificates than there was gold in the Treasury. That meant that it duped the American people by giving away their gold and then accusing the American people, once there wasn't enough gold to pay off their certificates, of being the hoarders. So they had to increase the amount of certificates in circulation without the law, the fundamental law of having every certificate backed by an equal amount of gold.
By the way, I want to let you know that there's an attorney listening to this who just sent a message. Prevailing in these arguments at the Supreme Court would be the most revolutionary case ever. Okay?
Well, wait till...
Well, it gets better.
Yeah,
Mr. Attorney, it gets a lot better. All right. Congress, the state, by the way, I have a document. It's Senate Document 43, and we're going to present this at the August 10th and 11th seminar. The state declared it was the owner of all property. How about that?
But it
the state
did it in
all of a sudden became the owner of all property.
But it happened in 1933, along with removing the gold and wealth from the American people.
Congress then declared it shall be public policy to discharge debt rather than pay debt. Now, in the common law, you pay debt. I give you my gold coin. I own your cow. Debt's extinguished. Discharge means I give you for your cow someone else's IOU. You didn't get paid. You just got an IOU. That's discharge. Okay, we'll go to the next one.
Yeah, but it's also good to know that you never own that cow. Once you get a discharge, you don't own it.
That's
Whoever
true.
owns the note, yeah.
When you pay for the cow with gold, you own it. When you give someone else's IOU for it, you didn't pay for it. So it's hypothecated.
Whosever name is on the note at the top is the actual owner of it.
Where did the government get the right to steal my gold? This is my gold certificate. Where is the power in the Constitution that it could steal my gold? It doesn't have that power. And what happened to paper currency? It became this. Note at the top, Federal Reserve note. It doesn't say United States note, but it does say they added, remember I showed you a Federal Reserve note from 1928. It was not legal tender. This is 1934, and it says this note is legal tender for all debts, public and private, but here's the caveat. It's redeemable in lawful money at the United States Treasury or any reserve bank. So what are the changes here? You now have paper that's not issued by the United States, but it's issued by the Federal Reserve Bank. The United States now is on the hook. The United States will pay, so this is your obligation to the United States, will pay to the bearer on demand $500. So this piece of paper is not $500. It will pay $500. I hope you all understand that. Yeah. This is not $500. It's a promise to pay.
There's an important point on this bill that you see in front of you. Whose signatures are on the note? You notice that the creditor never puts his signature on the note. So whose signatures are on this note?
the Treasurer of the United States and the Secretary of the Treasury, the debtor.
And you see the creditor's name at the very top.
So I want you to contrast this note to this. This is a certificate. This certifies. This is a credit note. I'm the creditor. I'm the owner of that. This is a gold certificate.
And to clarify what a certificate is, you know, outside of law, it's something that you may get as an award or something like that. But the lawful definition of certificate, it is a debtor's instrument. That means that if you're holding that certificate and there's an amount of gold on it, someone owes you the debt of the gold. And that's what certificate means in our society. Remember, you have a birth certificate. Keep in mind you have a birth certificate.
America. Yeah, I'm sorry, Ron. I was going to say here the United States of America would owe you that gold, but talk about the birth certificate for a moment.
Yeah, well, a certificate, as I say, the lawful definition and how it is used in our society, it is a debtor's instrument. And on the birth certificate, your name is as the commodity on it, who's the creditor of it? Well, every certificate goes to the Department of Commerce, and we have clear evidence of that because you can see that in the book. It'll actually show you a birth certificate with the Department of Commerce right on it.
Now, this is a 1950 Federal Reserve note, and please pay attention to the timeline here, because we were compelled to use these Federal Reserve notes by the corrupt Congress, by the treasonous Congress. This is Federal Reserve note. This is 1950. It says this note is legal tender, and please note, as late as 1950, will pay to the bearer on demand $10. So you still see that this is not $10, but it's a promise to pay $10, and it says here redeemable in lawful money. You can't read it, but it's redeemable. Lawful money at this time would still be silver. There was still lawful money in circulation. Let's look at a United States note, circa 1953. The United States, see, you notice here, United States note. This is not a Federal Reserve note, it's a United States note. The United States of America will pay to the bearer on demand $2. So this isn't $2 either. It will pay $2. Now look, all currency was redeemable. What happens next? Only 25 years later, they dropped will pay to the bearer on demand, which would have been right here, and they just leave the word $5. Hello. They just covered up will pay to the bearer on demand. And up here, it's no longer redeemable in lawful money. So all of a sudden, this, what you see in front of you, became $5. But you already saw in case law that you can't change the meaning of things. $5 was a weight. And all of a sudden, they changed it to this piece of paper. Or they denied you your access to getting the real $5. Here's a 1963 Federal Reserve note. Same thing. And this was the last remaining redeemable note. I remember using these in high school in the early 1960s. This is series 1957. This is a silver certificate, same as the gold certificate. It certifies that the United States is holding $1 in silver payable to the bearer on demand. And I had a lot of them after they went out of circulation, and I turned them in, and they were worth a lot more at face value because they would bring silver. But by 1967 or 1968, they stopped redeeming them so that those left with these were screwed.
Yeah, I think it's also a necessary point to bring forward is how this note is applied to the 16th Amendment at the time it's
printed. We're going to get there.
I just want them to keep that in mind, that the application of these notes are so crucial to that 16th Amendment, the Income Tax Amendment.
Right. So facts. At about this time, United States notes also became non-redeemable and their circulation ceased. And all we had was Federal Reserve notes, and the silver certificates ceased in 1964. So let's go back to Juilliard about what legal tender was. The basic requirements were they were issued by the United States and they were redeemable afterwards in a time of peace. Now we have notes that are not issued by the United States and they are not redeemable. So the Juilliard requirements have just been gutted. Now let's see if the Federal Reserve Bank is federal. Maybe it is. Here's a Lewis case in the Ninth Circuit. For these reasons, we hold that Federal Reserve Banks are not federal agencies for purposes of the Federal Tort Claims Act, and we affirm the judgment of the District Court. Right here in the California Ninth Circuit, it says that the Federal Reserve Bank is not federal. It's not a government agency, according to this case. It's neither federal nor reserved. I think everybody listening to this knows that. It's privately owned by international bankers. It's not registered in any state of the United States to do business. It's got absolute and dictatorial powers to create the illusion of wealth out of thin air. It steals from you simply by printing currency out of thin air and diluting what you think is yours. They're also debt notes. When they're issued, they carry interest, which has to be paid back. Here's from the Treasury Department website. What are Federal Reserve notes and how are they different from United States notes? The 12 Federal Reserve banks issue them into circulation. The United States isn't doing that. Notice, the government itself, as these notes are not issued by the United States, but by the Federal Reserve Bank, not in conformance to Juilliard. These notes are issued in exchange for U.S. securities upon which the government must pay interest. So the Federal Reserve Bank gets U.S. securities. The Federal Reserve Bank gives over these pieces of paper it prints up, and the Federal Reserve Bank has to get paid back those pieces of paper plus interest for what they printed.
Yeah. There's another point here is that in order to understand the worth of a law, the only time you get the understanding of the law is when the United States Supreme Court makes a determination and says this is what that law is. And that's what we're talking about, the Juilliard cases. That is precisely what the law is today. Am I right, Robert?
Yep, it is. All right, most people know this, Ron, so we're going to fly through it to something they don't know. Federal Reserve notes fail at issue being the United States. It fails at being redeemable. It fails at Juilliard. So let's fast forward. 1963. If a dollar is a weight of silver or gold, how does that people get to state that it is a dollar? If there is to be a standard of weights and measures, how does a piece of paper replace the metal and its weight? It does not except by fraud or malevolent intent. Now, this is what you wanted to talk about, Ron. What about, and we're not going to give you the cite on this. We're just going to give you the quote. Ron, take it from here.
Yeah, timing is everything. In 1913, March of 1913, three-quarters of the state enacted the 16th Amendment, which is your income tax amendment. Under that act, at the time, species or its equivalent, such as gold and silver certificates, were the payment for all taxes within the United States. And we have a case that stipulates that. However, later on that year, same year in December, the Federal Reserve system was created. It was passed in December. And what happened under that is they started issuing notes, as you can see, and they issued gold and silver certificates, and everything was copacetic. It went along, and up until 1933, you had those gold certificates, but yet the President of the United States stated that you were hoarders and you have to give over your wealth and you'll never touch gold again as far as these certificates. And that shows the trustworthiness of the government of the United States, because that was a promise to pay by the United States, and they reneged on it. So they're not trustworthy, are they? But everything was still copacetic because you still had species, gold or a silver coin, and silver certificates to pay your tax under the income tax law that was passed in March of 1913. But then in 1961, the last silver certificate was printed, and in 1964, the last silver coin was coined. So at that point, you no longer could pay your tax in the substance or the commodity used to pay your tax under the income tax law. You couldn't pay silver to discharge your tax, your debt to the United States. Now you have a non-redeemable note. Now we had the case, and we presented it to you, that says that they can't change the nature of the law merely because the circumstances have changed, and the law ceases to apply to the current circumstances. So the point is that these current Federal Reserve notes cannot apply to the income tax because they are not species and they're not redeemable notes or their equivalent. Every Supreme Court case, I don't care what it is, has always determined that that income tax has to be paid by redeemable notes or species. And that is the subject of our argument, is that no non-redeemable notes can be applied to that amendment unless it is repealed, revoked, unless it is amended by 3/4 of the states, and that has not happened.
I want to point out something else. At the time the Internal Revenue Code was passed, it was 1954. You saw from the evidence I gave you that the notes still in circulation, though they were Federal Reserve notes, which we say are unconstitutional and a fraud, those notes still represented money because they were redeemable. Let's go back to this case that's right in front of you, which is right after the Income Tax Act was passed. It says here that a dividend was a distribution in specie, gold or silver, and it's to be governed for all present purposes, that means taxing purposes, by the same rule applicable to the distribution of a like value in money. Specie, money. The measure of the income tax, and this is a Supreme Court case, was a distribution of specie or its equivalent in redeemable notes. Am I right, Ron?
Yes, you are, Robert.
This was a miracle that you found. Now we'll go to the next one. Whoops. The Internal Revenue Code, 1954. At the time, currency was not issued by the United States as required for legal tender. The currency was still redeemable. So the currency still represented money or the equivalent of money. This was even until 1954, but that changed when they removed silver. The Congress did not have the power to declare the notes of the privately owned FRB as legal tender ever, and you could see that in the Juilliard case. It didn't have the power to compel the people to discharge debt rather than pay it within the common law ever. And they perpetrated a fraud upon the people by lopping off the words at the bottom of the note, "will pay to the bearer on demand," and all they left was the words XXX dollars, to imply that the said paper was now actual dollars, which is in violation of the Coinage Act, which was never repealed. They're continuing the continuance of this fraud by condoning the unconstitutional application of tax from the 16th Amendment, because that amendment was based on income defined as an accumulation of gold or silver. Your income had to be measured in dollars based on gold or silver.
Yeah, and we already stated that the defining of all laws has to be the terminology of those words used at the particular time the act was enacted. And at that time, only gold and silver coin or certificates were used to pay taxes.
So we know that the Federal Reserve note cannot possibly apply to the 16th Amendment, but it could apply to something else. What else? What is the tax? Well, you happen to be dealing in privately owned notes in international commerce. You are importing and exporting said notes, which brings you into international commerce. For the privilege of transacting in those notes in international commerce, you're held to a tariff, and tariffs are constitutional. You want proof? Let's go to the infamous Brushaber case. This is the case that the IRS always cites as legitimizing the income tax. Ron, you found this.
Yeah. Well, first of all, you see where they call the income tax a tariff. A tariff is a tax on imports or exports. So you're in international law when you're talking of a tariff imposed upon the people. And this was Judge White that had rendered this determination. And at that point, one has to understand a couple of principles. There was a case brought by Lark, what is that case?
Larkin Rose. Larkin
Rose. And they relied on Section 867, I believe it was, of the Title 26. 861 of the income tax, Title 26. And they said, wait a minute, it states here that the only person that has to pay an income tax are those who deal with foreign nations or foreign corporations or foreign this or foreign that. And they lost, but they didn't understand why they lost it. As Robert said earlier, who distributes the Federal Reserve notes? Does the United States or does a foreign corporation distribute it? You saw a case there that said that the Federal Reserve is not party to the United States. It's not part of the United States. It is a foreign corporation, and every month you really do import these Federal Reserve notes. You export them. When you sign an agreement for employment or you collect from your patients, you agree to use these notes. You're equivalent to all your worth, your labor, your services are under these foreign notes, so you fall under that 861 of Title 26.
You're actually in international commerce, which can be taxed. Now, I know all of you know this one, but I want you to see it right out of the Federal Reserve Bank's publication, Modern Money Mechanics. In the United States, neither paper currency nor deposits have value as commodities. Intrinsically, a dollar bill is just a piece of paper. That's right. They scratched out, we'll pay to the bearer on demand. Deposits are merely book entries. Wait a minute. The tax was supposed to be based on specie, and you're depositing book entries. Coins do have some intrinsic value as metal, but generally far less than their face value. This here is an admission that a dollar coin of today doesn't have the value of what it says on its face, because a dollar is a weight of silver. It's not a weight of zinc or tin. What makes these instruments valuable? It's the confidence. Confidence. Now, how do you weigh and measure confidence? Remember, we're supposed to have a standard of weights and measures. How do you measure confidence?
Also considered they are fiat currency compelled on American people. So what confidence is
now
there?
We're going to get closer to licensure. There's guys who want to know about licensure, and we're coming to that, so please hang on. You need to see the currency is the heart of this. Ramifications of the toxic currency. How did they rope the rest of us into a diabolical dictatorship? Well, these notes were property of the Federal Reserve Bank. You know that. They're debt notes, and you can't question the debt. That's Article 4 of the 14th Amendment. So you can't even question anything when you walk into a court that's dealing with these banks. These notes fell because, notice here, they're property of the Federal Reserve Bank on loan to the United States. So the United States is responsible for this property of the Federal Reserve Bank. If I loan you my rake, you have it, you get to use it, but it belongs to me. But you're responsible. But because you have it, it's going to fall under Article 4 of the Constitution, territory or other property of the United States. It's your property. It's been loaned to you. So they fall under that draconian regulatory power in Article 4. You're using their property, so they get to regulate you for the privilege of using their property. If someone else uses your car, you get to set the rules and regulations for someone using your car. You're using their property so they can properly regulate you for its use. The United States was insolvent, so it stole the wealth of the American people, compelling us into a forever insolvency. We're using the equivalent of plantation or corporate script. We lost our ability to pay debt, we lost our property, and compelled to use commercial notes subject to Admiralty United States laws. Here's your new scale of justice. Not quite balanced, is it? And
See,
you're guilty.
And the point is in this scenario, as this picture is here, those who can't pay their debts are debtors. Are they entitled to immutable rights? Or must they be regulated to be controlled? See, and that's what it is. And earlier we said that the Congress has the right to borrow money. What money did they have the right to borrow? Legal tender? Was that ever an aspect at that time that they could borrow legal tender? Since the basis of all coined money would be gold and silver in this country, it would not be an implication. It would actually state that it was gold and silver coin or gold and silver coin that they had a right to borrow. And that's
actually, Ron, you hit it on point 2 days ago. The Constitution says that Congress has the power to borrow money, M-O-N-E-Y, on the full faith and credit of the United States. That's money it's allowed to borrow. It doesn't say it's allowed to borrow credit.
No. And the reason it would be in that vernacular is that there's a limit to borrowing under that vernacular. A foreign state would say, hey, that's it, I'm not lending you anymore. But what happens if the United States transacts with a fiction of law such as the Federal Reserve Bank and they have unlimited funds in legal tender? What happens to society? What happens to national debt? What happens to everything in society? We've seen the outcome of that right now.
Now, here's the proof that you don't own what you think is, you don't own what's in your purse or your wallet. There's a 10,000 limit on transactions in those notes. You can only move 10,000 in or out of the country, otherwise it can be seized. There's an inheritance tax. Even after you pay income tax on your $3 million, they'll take half of it for the privilege of passing on their property to your kids. Your money, what you think is your money in accounts, can be seized upon suspicion that you're using drugs or are a terrorist, or in the case of Maureen Long, she got her clinic closed down because she was using Laetrile and her account seized. Lawful gold coin has no limits in moving across borders. I'll prove that to you. This is from customandborderprotection.gov. How much currency can I move? You can only move $10,000 in currency or negotiable monetary instruments. It doesn't limit your movement of what is yours if it was lawful gold or silver coin. It's currency which belongs to them or negotiable monetary instruments. More proof that you don't own it? This is on Kitco's website. The Department of Homeland Security has the absolute right to seize without any warrant whatsoever any and all customer bank accounts and to make periodic and unannounced visits to any banks to open and inspect the contents of selected safe deposit boxes. Hello! They can seize your account without a warrant and open your safe deposit box.
Makes you feel comfortable, doesn't it?
Yeah. Now, here's how the government handles payment in gold. These are things you've never seen before. This is from the Internal Revenue Service. Somebody paid a tax with this $5 gold coin. Gold coins cannot be accepted as payment. That should raise a lot of questions in your head.
Because it's the money of accounts of the United States. It's the money of accounts of the United States, the lawful coin.
And they can't see it. Here's another one. Numismatic coin received as payment. We received the gold half eagle dated 1887, which weight, notice which weight, is $5. And in this letter, they're offering to process that as $5 at its valid legal face value. Everybody see that? At its valid legal tender, at face value. So one or the other is going to happen if you're dealing with gold. They can't see it at all, it can't be accepted as payment, or they can see it at $5. Now here's a case that I took to the Supreme Court. The defendant was me. I was the first person ever to lodge a gold coin. Go ahead, Ron.
Who was helping you?
Oh my God, Ron was right there with me the whole way.
Yes.
With his assistance, and it happened with him, we figured out a way to actually get a gold coin into the court, which they had to see, but they couldn't see it. You'll see in a moment. I was the first person since 1933 to get such a coin into the court. The court ruled against the man, saying he owed a considerable sum to the government, but strangely enough, the judge ordered the coin, real money, returned, declaring it to have no monetary value. This is a court of the United States? No, it's not. In the twinkling, Ron, well, talk about the courts and the currency. If it's a shekel, go ahead.
Oh, yeah. If to identify what courts you're in, you identify it by the money being used in that court. So if it's a yen, what court do you deem that would be? That would be the Japanese court, am I correct, or Japan courts? If it's a lira, it would be the Italian, and you can go on all through. And if it is a lawful dollar of the United States money of accounts, what court are you in? You would be in a United States court. But what if it's a Federal Reserve note of a foreign corporation? Which court are you in?
I think that should answer why we're losing cases in the courts. Because you're walking into a court that is dealing in the currency of the owner of the government. We have been lifted off the land where our rights arise and placed on the sea in commerce. We've become subject to diabolical admiralty commercial international law. You can't own property because you're using their property to acquire it. So that carries a lien by mere maritime hypothecation. You never paid for it. You used their property to buy your clothes. Now you understand why a jury can't judge the law as well as the facts. We became instant debtors, losing all of our unalienable rights. Another term that we can't pay off the debt is perpetual peonage. The courts, at the founding, they were called Courts of the United States. Their coin was the lawful coin. They remained the money of accounts of the United States to this day because the act was never repealed. In 1933, real money was stolen and replaced by these notes. Ron already said if you go into a court and it's using coin, then it's a court of the United States. Well, absent real money, in 1938, the United States created a new court called United States District Court, a mirror image of the lawful courts of the United States. And the money it's using is Federal Reserve notes. From the California Government Code, Ron, take it from here.
Okay, let me get to that. Yeah, Section 6850 of the California Government Code was once called the Political Code back in 1872 when the codes were first enacted. And as you can see, they defined money of accounts of the state of California, which is the dollar, the cent, and the mil. Well, those back in 1872 was the weight of gold or silver. Basically, they were using silver at the time. But you can see it is a weight of precious metal being used as the money of accounts of the state. 6851, this one basically, let's see, let me read it out loud. This chapter does not vitiate or affect any account, charge, or entry originally made, or any note, bond, or other instrument expressed in any other money of account. But such account shall or entry shall be reduced to dollars. So referring back to Section 6850, dollars or parts of dollars in any suit upon it. So they're referring back to how they're to receive other entries into the accounts of the state of California.
They have to be reduced. They have to be reduced to dollars, meaning
to dollars. Yeah, the weight,
yes.
the actual money of accounts of the state. Now we go to 6852, and it says all legal tender notes issued. Emphasize that word, issued, by the United States shall be received at par or face value, and the payment for all taxes due to this state or to any county or municipality corporation or municipal corporation of this state. So what they're saying is that the only notes they can receive are limited to United States notes that are issued by the United States. What about a Federal Reserve note? Are they issued by the United States? No, it is not in there. But I have no doubt somewhere behind the scenes they can accept Federal Reserve notes, but that's not the point. The point is you can't have a conflict of law here. And you have 6850 saying the money of accounts of the state is this, and then you have 6852 that says that they can accept at par. It doesn't mean the private person has to accept at par. It says that the entity called the state may accept at par United States notes or even Federal Reserve notes, but it does not give authority to place that compelled restraint upon the people.
Now, I'm going to show you something real interesting. This is dated 2007. This is from the California Franchise Tax Board. Same thing as the IRS. You submitted an invalid payment for the 2003 tax year. The gold coin, which you see here, that you submitted for payment is not a proper financial instrument and does not meet the payment criteria specified in the tax code. We are returning the enclosed document. They're reducing this to a document, and they're saying that there is still a lawful debt owing, even though lawful money was submitted. So the state of California can't see this either. It doesn't exist.
You know, Robert,
go ahead.
Oh, go on, Robert. I'm sorry.
I mean, then what is it if they can't see its own money?
I think it's important to show them how I got that gold coin into the accounts of the United States in that case. It's a very simple.
We should do it at the seminar. We should do it at this.
Okay, I will.
Yeah, we should do that at the seminar, Ron, because we're going to run out of time.
All right.
If the government can't see its own money, then what is it? The de jure United States or a de facto government? The state of California can't see it, and the states once created the United States. Now we are simply political subdivisions of the corporate United States. Now, do you really have to accept Federal Reserve notes? This comes from the Treasury right here, and it says, there is no federal statute mandating that a private business, meaning you, must accept currency or coins in payment for goods or services. Private businesses, meaning you, are free to develop your own policies on whether or not to accept cash unless there is a state law which says otherwise. Actually, in California, we do have a state law that says otherwise. It says that the money of accounts is the dollar, the cent, and the mill. Oops. There was no authority to return the money accounts of the state. So what happened in that letter was a crime committed by actors in the state. Is that right, Ron?
Yes, it is.
If they didn't have the authority to do it, they committed a crime. They cited a code that say remittances may be made in the form of check or money order. That's not a mandate. The code did not forbid the acceptance of actual dollars, aka also known as real money. All states will have a provision in law. I've seen the same thing in the state of New York. Because in the late 1800s, the only dollar was specie, including those circulating notes because they were redeemable. This is from a California Public Records request. California has no evidence of the money of accounts in its treasury. It could provide no evidence that Federal Reserve notes are issued by the government of the United States. It follows then that California is in violation of its own government code and Article 1, Section 8, Clause 10 of the Federal Constitution, which requires states to make nothing but gold and silver coin a lawful tender in the payment of debt. So California has been forced into violating its own laws and the Constitution by the federal racketeers with these notes. Same in every state. Conclusion. Every action by the state using or done in the name of foreign issued debt currency is repugnant to the current California and other states' laws. I've had other dealings with the Franchise Tax Board, I will let you know, and so far I've managed to clean them out, beat them off at every time on the issue of gold, because they were told when they tried to assess me for being a physician and holding a medical license and saying, oh, we know you must be making $200,000 a year, so we're going to tax you on this. And I said, no, I don't make $200,000 a year. I said, I don't make enough face value to even file a tax return. So they issued assessments, even though I swore under penalty of perjury otherwise. I took it up to the Board of Equalization, which is the reviewing agency, and I pointed out these laws. I pointed out my right to earn a living in gold, and guess what happened? Ron, what happened?
They had to basically dismiss it because, and the thing is that Robert is not the smartest guy in the world, because what he does is he exchanges, well, not him, but he exchanges a lot of Federal Reserve notes, and he has a loss at the end of the year because he accepted these non-valuable coins. Go figure.
Right. Go figure. There's ways to do that. No, I don't accept the Federal Reserve notes, because if I did, then I would have to report them under the Commerce Clause. All right, here's the plan, everybody, and this is why we really need your help. We really need your help, because we can't do this alone. And it is going to be costly to do, and so far it has cost a lot. It has cost a lot of blood, sweat, and tears. We need your help. We're going to have a writ of prohibition finished by our seminar August 10th and 11th, which we hope all of you out there will come to. This is going to be a boilerplate for similar petitions to go to the Supreme Court of every state as close to simultaneously as possible. Yes. In other words, go ahead, Ron.
Some states will not accept the writ of prohibition, but there are other vehicles to get it into the Supreme Court. So I just want you to be aware of that.
Yeah, they're going to have to be fine-tuned to the other states. Those of you who come, you're going to get a boilerplate to take into your state, and it will need to be fine-tuned for your state. The key features in the petition will be the unconstitutional application of non-redeemable Federal Reserve notes to the 16th Amendment, and Ron is also going to raise the issue of hoarding.
Yeah, but it would be the misapplication, the constitutional misapplication of the Federal Reserve note to the 16th Amendment, because it's a constitutional misapplication.
It's an unconstitutional misapplication.
No, a constitutional misapplication.
Oh, a constitutional okay, I got the negative in the wrong place.
Yes, you did.
It's a constitutional misapplication. Thank you, Ron.
You're welcome.
Now, Ron, I got to give Ron credit, and this is divinely inspired. I got an email from one of you, not an email, but a message as moderator. You know, you're going to get killed. I got to tell you something. If this is how I have to die, you know, the Islamists are willing to kill you for jihad. I'm willing to die for freedom. Not that I want to, but if I don't, then I've lived my life as a lie. And if I don't, and I know the truth, I will come back and be a slave. That's how I feel. Ron, you feel the same way too, do you?
I absolutely feel the same. Death isn't the worst thing that can happen to you. Restraints and being in peonage is.
And living a lie. Living the life of a lie. So we need you. We need everybody to jump on board and tear this I hopefully will tear through the country like the fires are tearing through the tinder dry West. The respondents, and this is, I'm going to tell you, I believe that Ron's idea is divinely inspired, because the person who just sent me the message said the courts are corrupt. You're damn right the federal courts are corrupt. They're Federal Reserve courts. We're going into the state courts because the states created the federal government, and the state is the final arbiter of the Constitution. The respondents, Ron, explain your idea is God-given.
Well, the only access the federal government has into the state is through the recorder's office. That's where it will notice of levy, writs of executions, liens, all sorts of penalizing documents to destroy a citizen's wealth. So the only way we can stop the Federal Reserve is to border up that door, that access to it. So what we're doing is putting in a writ of prohibition proving with incontrovertible evidence that the Federal Reserve note cannot be applied to the 16th Amendment because it was never intended to be, and if they wanted it to, they would have to revoke that or repeal that amendment and replace it with another amendment with 3/4 of the states voting, including us as the people voting on it. And I don't think that would ever happen. So we board up that recorder's office under the pretense that until the time the United States starts redeeming those notes, bringing them back through, then they have the right to use that opening to the recorder's office. And together with the recorders, we're also making respondents the deputy or the sheriff of the county, because the sheriff of the county holds the power to shut people down, to arrest them, and even because he takes an oath to uphold the state constitution and the federal constitution, when he sees a crime committed against either of the constitution, he has the absolute power to prohibit it. And he's going to be, our petition will include him in our prayers to do such a thing.
So the county sheriffs, we were going to have the county sheriffs issue a warning to all financial institutes in this county that he will prosecute any institutional official who cooperates with the central government regarding seizure of assets if the seizure of assets is based on the unconstitutional application of the 16th Amendment.
I should caveat this. We're not shutting down the Federal Reserve note. If we were, we'd destroy ourselves and every state across the Union. So we're not tampering with the note. We're allowing that to be the currency of the United States until it is properly redeemable. Then it can re-penetrate the recorder's office. But guess what happens when it's redeemable? You're not going to have a national debt based on non-redeemable notes that has been generated by non-redeemable notes. So there will not be, at that point, a huge debt. There may be some debt, I don't know. But what we're doing is we're bringing back the freedom, and this is the foundation upon which everything is built. And that foundation is the unlawful foundation. That Federal Reserve note acts like the blood system of a human body. When it's healthy and when it's redeemable or it's species, it brings nutrients to every sector of society. But what happens when it causes viruses such as depletion, inflation, deflation? And you see the results of it. We have major loss of jobs. Major manufacturers have left this country. Foreclosures, licensures coming into effect. Why do we need to be licensed? Well, debtors
we're going to get to licensing in a minute, Ron.
Okay, all right.
We're going to get to, and you're going to talk about that. But what we have in front of you now is it says every man and woman in the land can join in this case in a common cause because you have a right to lose. In other words, someone in New York can join on our California petition. We can join in the New York petition because this is a common right that we have lost.
Yeah. Yeah, and the common right has to be throughout the state or throughout the country. Well, this happens to be tailored right for that. And there's no retaliation by the state if you join a lawsuit, even if it's your next-door neighbor and it's about the seatbelts, and you say, wait a minute, that cannot be a police power. You have a right to join that suit against the state to prove that it is not a legitimate or constitutional police power. So this is what the potency of that common cause is. It gives us the proper means by which we can make ourselves heard within the court.
So I'm almost begging you, please come to this seminar, learn what we're doing, and we believe this is our last chance to restore the Republic and save ourselves. And it's something that we have to do. Because if we don't, what is going to be there for its children, for our children? there isn't going to be anything. Look at how fast it's collapsing, what's left. And we now have put it together so that we can take out the bogus currency that has enslaved us. We need you. You need yourself. We want to see this go viral. We should have the petition for California done at the time. There might be some fine-tuning afterwards. You'll have the opportunity to sign on and enlist your family, friends, patients, associates to get on board as well. They can become co-petitioners or co-plaintiffs. The issue is that they've captured us. They've imprisoned us. We need permission to even move. We need a driver's license and a passport. We're limited in the amount of their money that we can move or pass on. This is the last opportunity, as we see it, to restore the republic. The only other way it's going to happen is through a violent revolution, and boy, we don't want that. Taught at the seminar how to come and join in the writ as a co-plaintiff or co-petitioner and demand the states compel the feds to obey the Constitution, how to enlist others, how to remove yourself from transactions in their property. You'll see how to do that, and hopefully how you might be able to transact in specie, gold or silver, and remove yourself from the horrors that are out there using Federal Reserve notes. And we're going to deal with the unconstitutional requirement of licensure violating unalienable rights. And we need to get into that now, because following the writ on the currency, we're going to have another writ ready to go, which is going to take down the unconstitutional mandate for licensure for common law occupations such as healing. At best, we take out all licensing requirements. But at worst, we get a prohibition against boards from moving against licensees absent overt harm to the public at large. Read that last sentence. Absent boards from moving against the licensees without overt harm to the public at large, because I know some of you on this have lost your licenses or are at risk of losing your licenses, and Ron's going to finish this with a major discovery that he found.
Yeah, in my research, I came across the case that directed me to what police powers were and what they were not, what were constitutional ones and what were unconstitutional acts of the state or of the federal government. And it's a very simple concept. That concept says if you have an injury that causes harm to the general population, the entire population, it is the subject of a police power. But if you have an injury that is towards 10 people, 1,000 people, 50,000 people, that is not a constitutional police power, and the state is restricted from moving against that sort of thing. But that's as simple as it gets, and we can prove that. And this is where you go into the state with a writ of prohibition, prohibiting or challenging the constitutionality of these police powers under what they use. I'm not going to name what they use. That philosophy and that theory that all police powers are based on.
Ron, read this one in red. This is this is a quote.
This right out of
This is right out of the case. We're not going to tell you the case.
Okay. The police powers can be
exercised in August, but read it.
Okay. The police powers can be exercised only for public object and not as a part of personal regimen or health. The legislature has no authority to take away a person's property or control its enjoyment merely because, in its opinion, its use may be proved injurious to such person. The police power can be exercised only for public objects and not as a part of personal regimen or health. The legislature has no authority to take away a person's property or control its enjoyment merely because, in its opinion, its use may prove injurious to such person. And that is multiplied. Such persons you should probably have in there too. Your comment, Robert?
My comment is this case clearly delineates our unalienable rights. And we can do anything we want to do as long as we're not harming the public or society as a whole. Even if we're engaged in something that could injure the person before us. If it's done with fully informed consent, that is outside of the police power of the state.
So let's just give a couple of examples. Someone wants to build a nuclear power station. Should that be under the police powers? Absolutely. If it explodes, it destroys the public at large. What about if someone walks into the country with smallpox and starts contaminating people? Is that under the police powers? Well, most certainly it would be. But again, let's go back to that seatbelt. How many people die a year by not having seatbelts on compared to the percentage of the public at large? If it's a very small percent compared to the public at large, it cannot be a constitutional police power. What about doctors? How many people are injured in your field? Does it affect the public at large? If it does not, it is an unconstitutional application of police powers. You're on, Robert.
Well, I'm thinking of poor Maureen Long. I'm hoping she's on here because she was using Laetrile. No one was injured, and the police power of the federal government came and closed her down.
I just need to chime in and state that it's taken us 2 hours to lay the groundwork, and we're going to pick up exactly 2 weeks from now. And without the groundwork, you would have no idea of how you could even hope to challenge the state about anything, because you wouldn't know how to have standing or get to the right court or know what the problems are. So that's why if we think that there's a quick fix, there is not a quick fix. But when you take the time, and it has been a very exciting introduction, but there's so much more that we will be doing for those who really come in August and become part of what I will call a movement that can rescue our country from regulation hell. But I want to just say that we have to recognize that only when you know where the power is, and by getting into the money story and understanding that these admiralty courts we've been wasting our time in, there is no constitution there. You have no standing. And we have to make it very clear how you become a person with property. You own a gold coin. So we didn't cover everything today. We can't in 2 hours. But
well, Gary, I want to read this too. Look at this slide in front of you. It says the limit to the exercise of police power can only be this: the legislation must have reference to the comfort, safety, or the welfare of society.
Yes, it's really clear.
How much clearer can this be? In the assumed exercise of police power in the interest of the health, the welfare, or safety of the public, every right of the citizen might be invaded and every constitutional barrier swept away. They were dealing with a law that was dealing with tobacco. It has to have a relation to the whole public health.
But a lot of that's going to get directly into federal regulations, and we're trying to move as much power as we can to the states. So there's a lot here for us to digest.
And with regard to interstate commerce, this comes from a major Supreme Court case in the early 1800s. If there's compounding pharmacists amongst us, the inspection laws form a portion of that immense, massive legislation which embraces everything within the territory of a state not surrendered to the general government. Inspection laws, quarantine laws, health laws of every description are powers that were reserved to the states. Hello?
What about the FDA, Robert?
Same thing. But you have to note that by implication, your use of Federal Reserve notes have listed you off to the land and your direct access to the law of the land. That's why the first order of business is to go after the currency before we go after licensing, right?
Right.
Were there any questions, or do we have time for questions?
I'm willing to stay on if there's questions. If you want to open up the mic, you can. Here's the announcement for the seminar. August 10th and 11th at the San Francisco Marriott. You can either email me or Ron. And I want to quote Benjamin Franklin. We must stand together or we will all hang separately. My fellow colleagues who have never hurt anyone have lost their licenses and their ability to earn a living. And I know that it will come around to me if I don't do something about it now. I got the first law in Alaska passed protecting alternative medicine, And that's not my ego talking. Now that I know what's going on and I know what's happening and what my rights really are, I want to ensure that this doesn't happen to anybody, because if I don't, it'll come back and get me.
So all of our attendees need to know that this presentation from tonight will be on my website, gordonresearch.com. It will be up probably by this coming Tuesday, and you can send any of your friends there, and you need to listen to it again, because if you tune in 2 weeks, you will start to digest this. I've had the privilege of being at 2 conferences with Ronald McDonald and Dr. Rowan, and I have gone through these case laws, and I have looked at all the exact cases. So all of this makes total sense to me, having fought with the simple process of suing the AMA, suing the Medical Society, suing the Medical Board of the State of California. I have a kind of a pretty good feel of how the process works. And we can prevail, but we'll get their attention when we start filing this writ that can change everybody's life. It's important that we all really learn and spread the word and get many more people on in 2 weeks.
Any questions? Are the lines open?
Well, if I was on, Robert, I probably would have fallen asleep by now.
Oh.
No.
I know. When you talk, you put yourself to sleep.
Let's plan on a 2-week return and hope that in 2 weeks people have digested this, and we'll have a lively discourse, and we'll open mics and go into a different section in 2 weeks. But this was setting the stage without understanding how bad things really are. You can't go in and just solve a single problem of somebody losing a license for chelation or for growth hormone. We need to understand the big picture and get their attention with the process that we've outlined here, that everyone should have your friends participate in, whether you just want to give truthful nutritional information about a product or whatever you're trying to do, or tell people how great a colonic is. Why should we have all this nonsense about licensing so that a simple thing as giving people an enema that goes back into biblical times isn't possible under our current regulations?
Please tell your friends they can come in 2 weeks. We'll have another session, and spread the word as widely as possible. All I can say is I hope you enjoyed it. We can't do this without you.
Thank you, everybody. We'll tune off now and look.
Yeah, and I say thank you too. Thank you for listening.
Good night now.
Thank you, everyone. This concludes the webinar for today. Again, a copy of this presentation will be available on www.gordonresearch.com within the next 5 days. Thank you and have a wonderful